Copyright and advertising. This material is going to be very defense oriented. In advertising review, copyright questions are about ownership, clearance, and risk. The first question you ask in any copyright dispute is the copyright registered? Timely registration gives a plaintiff more leverage because of the possibility of statutory damages of up to $150,000 per work and attorney's fees. Registration of a U.S. work is required before you can sue. That is, a U.S. plaintiff can't begin a lawsuit in federal court without a registration in hand. It also can't get a final judgment in a federal small claims proceeding before the Copyright Office without a registration, though it can at least start the proceeding. If it's not a U.S. work, registration before suit isn't required, but for all works, only actual damages will be available in federal court in the absence of timely registration. And timely here means registration shortly after publication or at least before the infringement begins. By contrast, in a small claims proceeding, even without a timely registration, the claimant can seek up to $15,000 in statutory damages, though it can't seek attorney's fees. Since that's a tenth of the amount available max in federal court, it's a real limit, but it is also a lot of money when a reasonable license fee would have been $800. If there are real disputes of law or fact, it may be advisable for a defendant to opt out of the small claims proceeding, which is a new feature since 2020. If a defendant does not affirmatively opt out, it'll be bound by the small claims proceeding. Photographers have been major users of small claims so far, and since advertising copyright cases often involve photos, it's an option worth knowing about. So that's it for the introduction, and I will see you in class.